provide procedural guidance to lodging parties regarding the lodgement process for a grant with the South Australian Probate Registry. This video is general in nature and does not provide specific guidance with respect to all types of applications. Court staff cannot provide legal advice. If you require legal advice concerning your application, you should speak to a lawyer who specialises in wills and estates. So this video is about navigating Court SA and lodging a grant application. So we're starting on the Courts Administration Authority page, and you want to click on the Court SA online portal button. When you click on that, it'll take you to this page, to the Welcome to Court SA page. And the first thing to do is to register if you haven't already. But once you have, you click the login button and it will take you to this page. So the first question is, what would you like to do? And there's a number of options from the drop down: accessing a case, ordering a court transcript, searching for a grant of probate, but we're going to start a new case. Then what type of case do you want to start? Now there's lots of options here, but you need to scroll down to probate cases. If you lodge any other type that's not probate, you're in the wrong area. And we're going to follow through on the probate grant application, but there are a bunch of other options there as well. The other areas that the probate registry deals with, as I spoke about in one of my previous videos. So if we click on grant application, you find one of these big blue information boxes. So I encourage you to read that. And then we click lodge a probate grant application. So the first question on the online form is, are you representing yourself? So if you're a lawyer and listening in, you would tick no, and you would fill out your details in the boxes that appear. But if you represent yourself, i.e. you don't have a lawyer representing you, you tick yes. And today we're going to follow through as a self-represented party. Next panel is about details of the application. Did the deceased have an asset in the state of South Australia at the date of their death? Now this is fundamental to any grant application that is being lodged, because without an asset here in the state of South Australia, in the deceased's sole name as at date of death, the probate registry do not have jurisdiction to issue a grant. If you click no, for example, you get a red box saying you can't proceed any further. Therefore, you must have an asset here. If there's no asset at all, then you will need to look into lodging a grant in a different jurisdiction within Australia. Please be aware that all Australian jurisdictions are different, and you'll need to look at their individual processes before you go ahead and lodge a grant application. Now, a note on different coloured boxes. Red boxes are stop, you can't go any further. Yellow boxes are warning boxes, please read this, and blue boxes, like we saw on the previous page, are more of a for your information type box. So we're going to say yes, there is an asset here, and then select the type of grant application you wish to lodge. So if you've got this far, hopefully you already know what type of grant application you're looking for. And if you want more information about that, you can go back to the Courts Administration homepage and to the Probate Registry page, where there's information about the different types of grants and applications. There's also another video that I've done that covers some of that information too. So we're going to go through on a grant of probate today, as that is the most common type of grant. Though the questions in general on this smart form that we use is similar in all types of applications. We're looking for details of the deceased, details of the applicant, what the assets are, and after that, that's where the differences will start to appear. For example, if an oath is or isn't required. So the next question is, do you have a death certificate? If you tick no, in this case, you can continue with the application, as it doesn't block you from continuing, but you then will receive an email requesting that you provide a copy of the death certificate. When you tick yes, it wants you to upload a copy of the death certificate, and we ask that you upload it in PDF format and both sides of the death certificate. Now, details of the will. So the will is the most important document. It is your primary document in any application where there is a will, and hopefully you have the original, but you might only have a copy, in which case you'll need to have obtained an order from the court beforehand, or the court may already hold the original will. If you've already submitted an application, it's been rejected and you're resubmitting it. And if you do not have the will, again, you'll be blocked and you can't go through. You probably should choose a different type of grant application. So, and that's, you choose that one if there actually is no will at all. But we are going to have an original will for this application, and we have the question, is the will dated? We have 3 options, and typically most of them are all dated. So we click yes, we then click on the little calendar, we'd choose our date, and you can obviously go backwards, but some wills don't have a date or it's a partial date, and you'd choose whichever one is most applicable, and you would also then need to upload an affidavit trying to narrow down the date of execution of the will as much as possible. Now, is there any codicil? So a codicil is a document that makes a change to the will or adds to the will, and usually at the top of the document it'll recite, this is a codicil to my last will and testament, so you probably already know if you've got one, but the same applies to codicils as it does to will. Is there a date? Is it clear? No, partial. And if it is either of those, you'll need to upload an affidavit around that. And then just a general warning, you'll see it all over Court SA, but a general warning about original wills and original codicils is that if there are staples holding them together or clips holding them together, please do not pull out the staples or pull off the clips, and alternatively, don't add any. The way that you find or receive those documents is the way that you should be submitting it to the probate registry. So again, you upload the file as a PDF with all the pages there. You don't upload one page at a time. It'll be one single document, and this is because when the grant is issued to you, there'll be a sealed copy of the will and any codicils behind that. So all pages need to be included and they need to be of publishable quality. All right, on to details of the deceased. So hopefully we have a case where the name of the deceased on the will and the assets are all the same, but there are cases where we don't always have that circumstance. So if you have a case where is a different name on the will to on one of the assets, for example, or there's a name missing, you need to go and read Rule 356.27 of Chapter 25 of the Uniform Civil Rules 2020. So if you have the easy case and it's the same name on the will as what all the assets are in, you enter the full name, first name, middle name if applicable, and last name. Again, if applicable, we can have single names only. And then, is the name entered above the only name required to issue on the grant? You'd say yes. And do you need to record any other names for the deceased? You'd leave it at no. However, if you have the case where, for example, you've got a name in the will that is different to the name that's on the certificate of title for real estate, you would fill out the name that's on the will first. You'd then say, no, you need another name. You would upload an affidavit setting out the scenario and the situation, the fact that there is an asset in a different name. And then you would say that, yes, you need to record other names. And this is where you would enter the name that's on the piece of real estate or the certificate of title for the real estate. Now, data entering both of those names is really important because it will ensure all of the court documents have both names on them. Court staff cannot add names for you. If you need a name added once you've lodged your application, you either need to withdraw it or the registry will reject it. Right, now on to details of death. So, is the exact date of death known? It is literally just that. Do you have an exact date of death? If you don't have an exact date of death, you would click no. So a death certificate might say on or about date of death and it will give you a date, or it might say died between two different dates. That's where you would use these boxes and you would fill in whichever one is relevant to you. But we'll stick to yes, the exact date of death is known, and you have one of these little calendars that you can choose whatever the date might be. Now, next question, was the place of death outside of Australia? Most of the applications we see, the death occurred in Australia, and if that is your circumstance, you can leave it at no. But where the death occurred outside of Australia, you need to tick yes. This may lead to questions around domicile, or you might have a foreign death certificate as well, and then these might lead to further complexities, and if that is the case, you may wish to seek the services of a lawyer specialising in wills and estates. Then we have common places. So we have a list here of common places, but if none of them fit the details of your case, click Other, and then these three boxes appear. Please don't fill out all three boxes as you'll just confuse the system. It's either postcode and suburb or place of death. Place of death is really only used where the deceased died in a car crash or was lost at sea, basically where no specific suburb or postcode can be pinpointed. Now, last, residential address. This is generally the place where the deceased had been living for 2 or more months and they were unlikely to move to a different address. Something like respite care, that's not a last residential address because they were looking at just staying there for a couple of weeks in most circumstances and then moving back home. So home is the last residential address, and that is what you should type into the box. So this will actually bring up the address for you. If you start typing an address in, it'll give you a suggestion. You can choose that suggestion. However, if you can't find it, you can click on the address was not found using this search, and you can manually data in the address in. Is the address recited in the will the same as above? Quite often the will have been signed while the deceased was still in their family home, or where they'd been living prior to moving into a nursing home, so the address is different. And this is where you type in the address that the will recites, and it's just a way to connect all the documents and the pieces of information, but if it is the same, you just tick yes. Marriage details. Did the deceased marry after the will was signed? This is an important question because if the deceased did marry after a will was signed, that will has been revoked. Under the Succession Act 2023 from South Australia, that's the effect of marriage on a will. Then, did the deceased divorce after the will? Again, an important in question, because if we have husband and wife who appointed each other as their executors under a will and they gave everything to each other, but they subsequently divorce, the effect of divorce under our Act is that you treat that ex-husband or ex-wife as though they died at the date of the divorce. Therefore, they're unable to apply for a grant as an executor and they cannot be a beneficiary. So final question of the three, did the deceased register or revoke a relationship under the Relationship Register Act 2016 SA? And again, this question, registering and revoking, have the same effect as marriage or divorce. Now, details of the applicants. So this is either about your client if you are a lawyer, or if you're lodging as a personal applicant, this is about you. Quick note about the terminology regarding applicants and executors. If you are approving executor, that means you are the applicant or one of the applicants, and therefore you're going to be completing the probate application, or your lawyer will on your behalf, and you'll be signing documents and then administrating the estate. If you are a non-proving executor, that means you're not the applicant and you will not be proving the will and you won't be administering the estate. So for this part of the form, we're going to use a little example, and we're going to say that the will recites, I appoint my wife Anna, and if she predeceases me or is unwilling or unable to act, then I appoint my son Brad and my daughter Claire. Now, wife Anna has predeceased, and son Brad wishes to apply for a grant, but daughter Claire does not wish to be a proving executor. She wishes to be non-proving and wishes to have leave to be reserved to her. So for the son Brad, we would put his information, his details in here under details of the applicant. So he'd be an individual. We would put in his full name, address, and contact details. Now, contact details are very important if you're a personal applicant in particular, because email is the main way that the probate registry staff contact the lodging party. So if you type in the wrong email address, we'll have to send a letter out to you instead. Now, is the applicant's name in the will the same? Quite often there'll be spelling errors, or a name has been changed due to marriage or divorce, or by deed poll, in which case you would tick no and then upload an affidavit, and you'd be looking at either Form Prob 42 or Prob 43. And the affidavits are about setting out that the different names, the one in the will and your true and legal name when you're lodging this application, that you are one and the same person, as described in the will as going to be described on the face of the grant. So it's linking the two names together essentially. All right, so then is the applicant's name does not appear on the death certificate, we select no. So if the applicant's name is different, now this is just, we want a letter to explain the difference, whether it's because there's a misspelling or a name has been omitted. Just upload a letter for the registry. However, please do note that on death certificates that the Registrar of Birth, Deaths and Marriages issues, you'll never see the surname for children. You'll never see the married surname of a wife or the mother of the deceased. It's always the maiden name that is recorded. And if you have a name where you're meant to have a uppercase letter and then a lowercase letter, such as McLean or McLeod, Birth, Deaths and Marriages put a space between the little case, lowercase letter, such as the C, and then the next letter. That's not indicating that there is actually meant to be a space. It's indicating that it's meant to be a little c. Typically it's a C. Alrighty, so then you can add another applicant if there's another proving executor, but in our scenario we only have one proving executor being Brad, and then we still have the wife Anna and the other child, the daughter Anna, to clear off. So are there any other executors named in the will at the same level of priority or higher who are not applying for the grant? We would say yes to this question. Now, for the wife Anna, we would again say she's the individual. We would fill out her name, and then we would say that she has died, and we would give her date of death. To add Anna, we would hit add another executor. We would say she's an individual again, and we would choose leave to be reserved. Now, there are a few other options. I would recommend having a read of this blue box as to the other options that are there, because you might have a scenario where the executor actually has decided to renounce, or the executor is unable to act, and other should only be chosen when the above four options don't fit the facts of those for options. Alrighty, so if we move on then to other details. So, are there any administration or protection orders made by any court or tribunal relating to the deceased? So, this is talking about court orders or tribunal orders, and the tribunals are typically the South Australian Civil and Administrative Tribunal or the Guardianship Board. Now, these are really important because they quite often will have a paragraph restricting the ability of a person to make a will, or they can only make it in certain circumstances. So if you have one of these, you need to upload it to the file. You need to upload all orders from the original all the way through to the reviews to the last one before their death. But if you don't have one, just tick no and you can continue on with your application. Now, assets and liabilities. So the end goal really of obtaining a grant of probate or any type of grant from the probate registry is to be able to access the assets and administer the estate, either according to the will or according to legislation if there is no will, i.e. intestacy. So a few key points. One, again, there must be an asset here in South Australia. If there is no asset here in South Australia, then the probate registry doesn't have jurisdiction to issue a grant. So the asset here in South Australia can be furniture and effects or a car or real estate or a bank account, but there must be one. You should be careful around shares and superannuation because quite often those are located on the eastern seaboard rather than in South Australia. In addition, do not disclose details about jointly held assets. Anything that is jointly held does not go into the statement of assets and liabilities. The registry is only interested in assets in the sole name of the deceased as at date of death. Alright, so asset type. So we have a long list here of different types of assets, and if you click on one of them, it'll prompt you for the information that is required. So for real estate, we've got the address, the volume number, the folio number, and the value of the real estate. Now, for real estate, it's really important that you use the Valuer General's valuation or a licensed property valuer's valuation. We're not interested in your own estimate or a real estate estimate or what somebody thinks that the going rate in the area is. We want either Valuer General's or a licensed valuer's property valuer's valuation for the piece of real estate. Now, it's really important to data enter your details correctly, particularly the address, the volume number, and the folio number. Registry staff do not check if you have entered these details correctly. We do not call the Land Services Office, we do not call banks, superannuation companies, etc. You must ensure the information is correct that you have data entered, or it's possible that when you go to ask for that asset to be released with your grant and your registrar's certificate, the organisation will turn around and say that the information is incorrect. Then you'll have to come back to the registry, do a further process, and then get an amended registrar certificate to then have the asset released to you. So easier to get it right from the start. Now, bank accounts, please include the name of the bank and the branch location. Retirement villages and care accommodation. So this, you'll add the provider name such as Estia, but the address, make sure that is the address of the location of the nursing home they were in. It doesn't need to be the head office address. It's the location of the nursing home itself that the deceased was living in prior to their death. Cash in hand. That one is literally cash in hand. It's not cash held anywhere else. It is cash held on the person, in their wallet, under the bed. That is where you would enter that amount. shares or similar investments, please provide the full name of the company, such as Commonwealth Bank of Australia, whatever it might be, the number of shares, price per share. Price is at date of death, not the price when you lodge the application, or when it was a high or low price, or when the deceased bought the shares. It is at date of death. So you can go onto the ASX website, and that allows you to go back historically and have a look at what a value was at the time of death. All right, and then if you're not sure where the asset might fit in, you have other asset type, and this gives you a free text box to enter in the description of the asset. So you essentially need to enter enough detail to describe the asset that if somebody else looked at it, they would be able to know what that asset was. Right, now if you think there is superannuation money and you haven't yet had a response back from the superannuation fund, or they won't release the information until they see the grant, please tick yes to this question, because that flows into when you have to come back and disclose it to the court at a later date. Essentially, it means that you won't have to pay the filing fee for the additional asset if you've ticked yes for superannuation. Not for any other type of asset, it's purely for superannuation. Now, did the deceased have any liabilities? So if you click yes, then it's the same as when you're putting in assets. You give a description of the liability. Please put in each liability separately. So if there's an ambulance account or a pharmacy account, you do them as two separate liabilities rather than one big whole one. Now again, you have that warning which we've repeated over and over again, that says please make sure that at least one asset is located in South Australia, even if it's furniture and effects and everything else is on the eastern seaboard. The furniture and effects gives the probate registry the jurisdiction to issue the grant. However, we would probably question whether or not you need the grant from South Australia, or if you'd be better off getting it from wherever the bulk of the assets are located, because please do be aware that sometimes the asset holders, they want a grant from their state, not from a different state that maybe that's where the will was written, or the will was written and because the deceased lived there, or that's where the executor lives. The asset holder will determine which state they want to get the grant from, so do have that conversation before you apply. Now, we have other affidavits or documents that you might need to upload. So you might have an affidavit that you know you need to upload, such as you took out the staples of the will by mistake before listening to this video. So you'll need to do a Form Prop 39 affidavit. It's an affidavit of plight, condition and finding, and you would upload it here for the registry. As well, if you had a letter that you needed to upload or any other supporting documents, you can upload them here. And then this whole online form is your oath of executor and your affidavit of assets and liabilities. So by ticking these green boxes that appear one after the other, you're saying that to the best of your information, knowledge and belief, all the information that you have entered is true and correct, and that you'll administer the estate faithfully and according to the law. If you're a lawyer, you're saying your client confirms the same. Now, once you get here, you can either continue to proceed if you're happy with the information that you have entered and you've checked it over, or you can save it for later, and that'll then go into your draft section. So you can come back to it with fresh eyes, or you can get somebody else to check it over before you hit proceed. But once you do hit proceed, it will take you to a card payment. Payment is only by card. There is no ability on the system to accept cash or check. And once you've paid for it, you'll be given a prop number created specifically for this file that you have lodged, and the application will now be with the court. If there is a will or an original grant and you're applying for registration of an interstate grant or reseal of an overseas grant, then these original documents must be sent to the probate registry. Your application will not be considered until the registry has received those documents.